Welcome back to Legally Dephine. My name is Dephine. This is part B of our lecture Sources of Law, and we are going to cover custom and authoritative texts. This is going to be a lengthy video, so let's get into it. Customs are rules that become legally binding in the course of time through observance by the community in question. They are not necessarily written down, but a community becomes accustomed to regulating its relationship in a particular way, and many of its members regard that particular way of doing things as legally binding. There are two types of custom: general custom, which applies in the fields of law such as commercial law, banking, and so on, and African customary law, which regulates the lives of indigenous Africans. General custom. In terms of general custom, a custom is legally binding if it satisfies four requirements. Number 1, it is reasonable. Number 2, it is long binding, that is, it is clearly established. Number 3, it is uniformly observed. And number 4, it is certain. The onus to prove each of the four requirements mentioned above is on the person who relies on the existence of a custom. However, problems may arise with some of the requirements. For example, given the varying conceptions on reasonableness, different courts may come to different conclusions on whether or not an alleged custom is reasonable. According to Vogt, a custom is not reasonable if it is contra bonus mores, that is, if it is contrary to public morality. Regarding that the custom be long binding, in the sense of having existed for a long time, there is no minimum period except to say that the custom must have existed long enough for it to be generally known. One example is the custom of bankers charging interest on overdrawn accounts, a custom that has been given the force of law. African customary law. African customary law is a specialized form of law in Zimbabwe. Zimbabwe has what is termed a dual legal system, comprising of general law and African customary law. This means that in certain matters, there is potential application of two different systems of law with two different consequences. A person may or may not be bound by customary law. Thus, one person may be bound by customary law and subjected to the consequences of that law, whilst another may be governed by general law with different consequences. This is what is meant by dual legal systems. There are also some matters in which some questions are governed by customary law and not general law. How do we know if customary law applies in a particular case? Whether or not customary law applies in a particular case is governed by the provisions of the Customary Law and Local Courts Act, Chapter 7.05. Section 3, Subsection 1 of the Act reads, "Subject to this Act and any other enactment, unless the justice of the case otherwise requires, customary law shall apply in any civil case where the parties have expressly agreed that it should apply, or regard being heard to the nature of the case and the surrounding circumstances, it appears that the parties have agreed it should apply, or regard being heard to the nature of the case and the surrounding circumstances, it appears just and proper that it should apply. The general law of Zimbabwe shall apply in all other cases." There are very few statutes that impose the application of customary law. Thus, in most cases, reliance has to be placed on applying the provisions of Section 3 of the Customary Law and Local Courts Act. An analysis of Section 3 of the Customary Law and Local Courts Act yields different interesting features. The first feature is that customary law applies in civil matters only. It does not apply in criminal matters. In State v. Machkenyika, the High Court dealt with a case involving the crime of incest. It set aside the conviction of the two cousins who, according to customary law, were prohibited from having sexual relations. Under general law, there were no similar provisions. Therefore, the magistrate court had convicted them on the basis of the prohibitions of customary law. In other words, the court had used customary law to determine whether or not the crime of incest had been committed. The High Court set aside the conviction on the basis that customary law did not apply in criminal matters but civil matters only. The second feature is that customary law only applies where the plaintiff and defendants agree that it should apply. The only point to note here is that the agreement must be genuine. The agreement may be express or implied. That is where, with regard to the nature of the case and the surrounding circumstances, it is reasonable to assume that the parties are in agreement. Thirdly, when there is no agreement, the court may impose the application of customary law, but only on the basis that it is just and proper. In deciding this, the Act requires the court to consider surrounding circumstances. Surrounding circumstances are defined in Section 3, subsection 2 of the Customary Law and Local Courts Act as follows. For the purposes of paragraph A of subsection 1, surrounding circumstances in relation to a case shall, without limiting the expression, include the mode of life of the parties, the subject matter of the case, the understanding by the parties of the provisions of customary law or the general law of Zimbabwe, as the case may be, which apply to the case, the relative closeness of the case and the parties to the customary law or the general law of Zimbabwe, as the case may be. The court makes an overall judgment of whether or not it is just and proper after weighing up these four aspects. So, generally, the decision is at the discretion of the trial court, and an appeal court will not interfere with the decision, even where it might form a different opinion on the facts. An appeal court will only intervene and change the decision of the trial court if, having regard to the facts, the decision reached is grossly unreasonable. A case that illustrates the application of customary law where there is no agreement between the parties, but the court imposes on the basis of just and proper is Lopez v. Nxumalo. In this case, the appellant was a white Portuguese man and the respondent was a black Zimbabwean woman. The appellant had seduced the respondent's daughter, and the respondent wished to sue him for seduction damages under customary law. The appellant argued that he did not know African custom and was not acquainted with African customary law. He then sought to have the matter heard under general law and not customary law, arguing that the community court had no jurisdiction to hear the matter. The community court rejected his arguments and held that customary law applied, therefore it had jurisdiction. The appellant then appealed to the Supreme Court, but his appeal was thrown out. The Supreme Court noted that the fact that the appellant did not know African custom and was not acquainted with African customary law was merely one of the factors taken into account. That factor had been weighed against the fact that the respondent and her daughter did not understand general law and lived a life guided by customary law. It further noted that the community court had weighed all these factors and come to the conclusion that customary law should apply on the basis of just and proper. Therefore, the appeal court found no basis for interfering with the decision of the community court. Finally, the choice of law formula in Section 3 of the Act applies unless the justice of the case otherwise requires. The expression "unless the justice of the case otherwise requires" has significance. It means that where the choice of law process yields customary law, but the content of customary law would attain an unjust resolution, general law and not customary law should apply even if the parties had agreed that customary law should apply. An example where the court resorted to the justice of the case is the case of Chapeyama v. Matende and another. In this case, the appellant and respondent were married under customary law. The marriage was not registered under the Customary Marriages Act, Chapter 7.05. Therefore, it was an unregistered customary law union. They lived together for 7 years, having fallen in love when they were in grade 7. They had 2 children and had acquired considerable property through their joint efforts. The appellant terminated the marriage relationship and sought an order from the courts to have the respondent's name deleted from the registration certificate pertaining the house. The court was of the view that the parties were married under customary law and their rights and duties were governed under customary law. According to customary law, the respondent was only entitled to the Amai and Maoko property regardless of having contributed substantially to the matrimonial assets. Hence, there was no need for a general distribution of the matrimonial property. On the face of it, applying customary law yielded clear injustice. The court held that this was a proper case to resort to the justice of the case and refused to apply customary law. There are other cases in which the court applied the justice of the case principle, for example, Matibiri versus Kumire, Mtuda versus Ndudzo, and others. Make sure to read those. The interplay between customary law and general law has been problematic in some instances. This is best illustrated by cases involving the rights of women under customary law. In Katekwe versus Mchabaiwa, the Supreme Court held that the father of an African female who had attained the age of 18 no longer had the right to sue for seduction damages under customary law in respect of his daughter. This was because the Legal Age of Majority Act had changed the status of women even under customary law, and it was argued before and accepted by the Supreme Court that the reason why women would not sue on their own under customary law was because they were regarded as perpetual minors. Therefore, the Legal Age of Majority Act gave them the majority status upon reaching 18, hence giving them rights they would not enjoy under customary law. This reasoning was followed in Chiwa versus Mangwende, where it was held that one of the consequences of the Legal Age of Majority Act was that a woman who had attained the age of 18 could be validly appointed as an heiress of her father's estate under customary law, with the same rights and duties of those of the male heir. The position in Chiwa versus Mangwende was later changed in Fareta versus Fareta. In this case, it was held that the eldest son was the natural heir of the father's estate, even if there was an older female sibling, and that the situation had not been affected by the Legal Age of Majority Act. Thus, Chiwa versus Mangwende was restricted to where there was no male heir. In Murisa versus Murisa, the Supreme Court also confirmed the customary law rule that a wife cannot inherit from her husband's estate. In Magaya versus Magaya, the Supreme Court delivered a bombshell. It held that Katekwe versus Mshabaiwa had been wrongly decided. The Legal Age of Majority Act did not affect rights and duties under customary law. According to Magaya versus Magaya, women have no rights of inheritance under customary law, not because they are minors, but because they are women in an African society. These and other disputes on customary law rules of succession have been heard in the courts. Generally, the application of customary law depends on what it is that the community in question regard as binding custom, and the only method to ascertain it is through expert witnesses on customary law. The witnesses may either be academics or elders in the community who have knowledge of the customary law practices in that particular community. This concludes customary law, and now let's move on to authoritative texts. If you find this lecture beneficial, please hit on the like and subscribe buttons. Don't forget to click on the notification bell so you never miss on our latest lectures. Your support greatly helps us continue with our work here on Legally Dephine. Let's continue with the lecture. Authoritative text refers to writings by leading authorities in the field of law. As already noted under the common law system, treatises written by Roman Dutch jurists are authoritative sources of the Roman Dutch law and are treated as such by the courts. Reference must also be made to modern textbooks and other scholarly articles. Even though these do not have inherent authority on their own, they may be regarded as very persuasive authorities when they are explaining a legal point which is not clearly covered in legislation or case law. The persuasive nature of an opinion of an author depends on these three things. Number 1, the standing of the author among judges. Number 2, the scholarly level of the piece of work involved. And number 3, the degree to which the nature of the presentation is convincing. An essential component of a system based on precedent is where these precedents are recorded, and this is law reports. Judgments from superior courts, the High Court, and the Supreme Court are required by law to be in writing. This also applies to courts lower than the superior courts. Once a superior court has delivered a judgment, it is made available to the public. Most countries, including Zimbabwe, have a system in which all judgments delivered by the superior courts are scrutinized by legal experts with a view of selecting some of them for publication in official law reports. A judgment that is not selected for publication is described as unreported, and that which is published is described as reported. However, an unreported judgment has the same precedent value as a reported judgment. In Zimbabwe, the official series of reported judgment is called the Zimbabwe Law Reports. A full law report includes the following details: the names of the parties, the court in which the case was decided, names of the judges, date or dates of hearing, list of cases discussed or cited, names of the lawyers, an indication of whether the judgment was reserved, and a head note. Zimbabwe has only one set of official law reports, but other countries have several sets. I know this is a very lengthy video, and this concludes part B of our lecture Sources of Law, Custom and Authoritative Texts. Here on Legally Dephine, we go all the way. To those who have watched until the end, thank you so much. Please don't forget to subscribe, like, and share the video. Until we meet again.